So obviously the topic of today's webinar is your insurance worth the paper it's written on? And many businesses have questioned that, I think, over the last 16 months in light of the COVID-19 pandemic and their inability to claim for business interruption insurance. So I'm going to provide a little recap on what's happened regarding business interruption insurance claims and just provide some top tips as to what to do if you potentially do have a claim that can be brought. So next slide, please. So a bit of a recap. Business interruption insurance, it's there to protect businesses against the loss of income due to any disruption of trade. But typically it is providing cover where there's been some physical damage to property. So by way of example, gas explosion, flood, fire, etc. It's generally accepted that COVID-19 does not cause physical damage to property, and that's where a number of businesses have come unstuck in light of COVID-19. Some policies do contain what's called extensions, whereby cover is provided for business interruption insurance without there needing to be a physical damage to property. So what we found back in March 2020 is that many policyholders sought to claim under their BII policies. Many were initially refused, and that resulted in outcry across the sector, across all businesses where people felt that they were being wronged. Next slide, please. So in light of that, and as many of you may know, the FCA took an unprecedented step and decided to bring a test case through the court last summer, seeking clarity around a number of issues regarding business interruption insurance. And the particular focus was on these non-damage related extensions. So notifiable disease clauses, denial of access clauses, or otherwise sometimes called prevention of access clauses, and hybrid clauses. And they include elements of both the notifiable disease and denial of access. Typically, those are Hiscox related policies. What, for a lawyer's perspective, was a very swift court case. The matter was issued last summer. High Court judgment was handed down in September, and then the matter was fast-tracked to the Supreme Court with judgment finally handed down in January 2021. And in a general sense, it was really positive for policyholders, and that's certainly the message that went out in the media, albeit there is a need to caveat that slightly, as what has been uncovered over the course of the last few months is there's still a need to satisfy the terms of the policy wording. Next slide, please. So taking the notifiable disease clause, I've put an example up on this particular slide of what we typically will see in an insurance policy where cover will be provided. So as you can see, it says any occurrence of a notifiable disease within a radius of 25 miles of the premises. That radius could be 1 mile, 1 kilometre, etc. So that distance can vary. But the key issue is how is notifiable disease defined? So the example up on your screen is an illness sustained by any person resulting from any human infectious or human contagious disease. And then it leads on to say that a competent local authority has been notified to an outbreak has been notified to the competent local authority and consequently action has been taken. Other examples that we see is where there's reference back to the health regulations, and COVID-19 is listed within the health regulations since March last year. So in order to satisfy this clause, you'd need to just prove that there was at least one case in the relevant geographical area, and the FCA has helpfully produced a tool on its website enabling you to type in the address of a premises and it will draw up that information. If you're able to satisfy these necessary tests, then you should be able to claim all your losses flowing from COVID-19 and the government's response. And obviously that's subject to any indemnity limits within the policy. And typically we also see that with the extensions, they're limited to a certain range in time duration. So for example, it might say a limit of say £100,000 and covering a 3-month period. What we've also discovered, though, over the course of the last 16 months is that many policies have a prescribed list of notifiable diseases, or otherwise they might be listed as specified illnesses. This can make a case more difficult. It will depend on the exact wording of the policy as to whether or not that's an exhaustive list. So again, it's always worth having that double checked. Next slide, please. Turning to the denial of access or prevention of access clauses, these can be triggered if you were prevented from accessing only part of your premises as a result of actions taken by a public authority. And it has also been determined that the trigger will be as soon as the guidance was issued by the government. It doesn't necessarily have to have become law. However, what's also materialised in respect of these clauses is that if, for example, it states that it's an event that has taken place in the vicinity of the premises to which local authority intervention has resulted in the closure of the business, then the court has determined that that seems to be focused more on a local incident rather than the national response to the pandemic. So again, it's very much sort of policy by policy specific as to whether or not the prevention of access clause will be triggered. Next slide, please. Therefore, at this stage, in taking that all into consideration, is it worthwhile at this stage reconsidering whether you have a claim? And in our view, yes, it is. It's certainly worthwhile going back, reviewing the policy wording, liaising with your broker and potentially getting some legal advice. There are a lot of nuances with these policies, and there's a lot of ambiguity. So even if you've had an initial rejection, it is worthwhile going back and double checking. The FCA test case judgment is binding upon the 8 insurers involved, but it also has provided authoritative guidance regarding the interpretation of these policies. As already mentioned, there is a lot of ambiguity, and that remains the case despite the FCA test case. It hasn't covered off all and every issue. Therefore, as I say, it is worthwhile getting a second opinion. Next slide, please. So in terms of some of the issues that we're seeing at the moment in respect to the claims that we're dealing with, here is an example of a couple. And one issue that is definitely waiting to be heard by the court is whether or not COVID-19 falls within the definition of SARS. What we've often seen is that SARS is listed as a specified illness in a policy, and the official medical term for COVID-19 is SARS-CoV-2. So a question mark remains as to whether or not that falls within that SARS definition and therefore can be claimable. That wasn't considered as part of the FCA test case, so it really is just a matter of time. Another issue that we're encountering on a more regular basis is that policies state that there needs to be presence of COVID-19 at the premises. And often this can be difficult because if you think back to March last year, there wasn't the testing capability. And so whilst people might have had symptoms, it can be difficult to prove. Again, what we've been recommending to clients is that they they ask questions of their staff and their employees and gather some witness evidence and or their customers to identify whether or not there were people with symptoms in the premises at the material time. And another issue which is causing some debate is around some of the savings that businesses have made. So when it comes to quantifying the losses, what we've seen with a number of clients is that when they were initially rejected back in March 2020 from being able to claim business interruption insurance, they took steps to mitigate their losses generally and therefore put salary cuts in place across the board with their staff. If you look at the strict wording of many of the policies, those savings need to be taken into account when considering what losses have been sustained. And obviously that doesn't sit comfortably with many businesses who feel that insurers are profiting at their expense. So again, an issue that remains under dispute and one that I'm currently dealing with on a number of my matters. Next slide, please. So in terms of top tips at this stage, obviously we're 16 months into this pandemic and looking to come out the other side. But at the same time, it is important at this stage that you do go back and scrutinise your policy. Is there ambiguity in the policy wording? Are there issues to be explored? And is there potential to bring a claim? If so, reach out to your broker, seek advice from professionals, do explore the merits of a claim. just to make sure that that initial no could not potentially be followed up by a potentially or a yes, and there may be monies there that can be recovered. If you do have a claim, do take steps as soon as possible. The notification dates were extended as a result of the FCA test case, but the last thing you want to do is miss any deadline. Most clients will have taken steps back in March 2020 to tick that necessary box, but again, it's worthwhile just making sure that's the case. And just leading on from what I've already said, really challenge the stance of the insurer if there's merit in doing so. Don't just necessarily accept no as sort of the final answer. There may be areas of ambiguity and avenues to explore. And also look at whether, there have been a number of lockdowns over the course of the last 16 months, both local and national. So it's worthwhile just exploring whether or not you've got any additional claims that can be brought, either in respect of a new policy or in respect of subsequent claims, lockdowns within the period of the same policy. When quantifying your loss, it's really important to provide as much evidence as possible and explain how those figures have been calculated. Again, consider seeking professional advice. They will be scrutinised and challenged, so the more information you can provide, the better. And in accordance with what the FCA has recommended, it's also worthwhile asking for an interim payment whilst your claim is being quantified. As I say, the FCA has encouraged insurers to do that, so it's certainly worth asking the question. Next slide, please. And so finally, what to do if your claim is rejected. It's really worthwhile having a look, consider whether there's a complaint or appeal that can be brought, having a look at what the complaints procedure is in your policy, and making sure that you adhere to what is set out. We're also seeing a number of complaints and decisions being made through the Financial Ombudsman Service. At the moment, there is a limit in terms of what the Financial Ombudsman Service can award, up to 350,000. But again, it's a lower risk strategy if you do qualify. So again, something worth exploring. And finally, it's then a question of exploring the merits of any court proceedings, considering your policy wording, seeking advice to explore whether or not you can look to challenge further.